we're now ready to move into our afternoon penultimate panel, which will be our splendid junior scholars paper presentations. And I'm delighted to turn this over to Renee Lerner of the George Washington University Law School faculty. Renee, over to you.
Okay, well, thank you. This is a marvelous panel. It's a large panel, as you will observe. We have 5 papers from junior presenters, and we have 2 intrepid commentators. We have John Harrison, who's going to be very busy this afternoon from the University of Virginia School of Law, and we have Robert Miller from the University of Iowa College of Law. So they will be commenting on the 5 papers we're going to hear. First by Stephanie Barclay and of Notre Dame, then by Tyler Lindley, clerking for Judge Gregory Katsas of the DC Circuit, by Caleb Griffin of the University of Arkansas School of Law, and Chad Squitieri, Catholic University Columbus School of Law, and finally, and Ilan, you must be last in just about every alphabetical order, right? Finally,
Could
Ilan
do it by
Wurman.
first name.
Ilan Wurman from Arizona State University. And with that, because, as I say, we have a number of panelists and a number of commentators, we will just launch right into it. So Stephanie, please take it away. And Stephanie's paper is entitled Constitutional Rights as Protected Reasons.
It's a pleasure to be here with you all. Thank you so much to the Federalist Society for hosting this great event, and for the other panelists and our commentators, especially for taking time to look at these papers. I guess to start, I'll talk about the question that motivated this paper for me, was just thinking a little bit more about what does it mean when a constitutional system decides to memorialize a right in the constitutional document. This isn't a question that is limited to our constitutional system. It's not primarily an originalist project, although I think that the proposal I offer is consistent with an originalist understanding of our Constitution. But it's more of like a theoretical, philosophical question about what's the anatomy of a constitutional right. There's a lot of scholars who argue that there's something inherent in the nature of a right that requires balancing, judicial balancing of interests. So if we think about a conflict where there is a government-proposed highway widening project, and that highway widening project is advocated in order to decrease car accidents and improve public safety, but the planned project will destroy a Native American sacred site near the highway. A question arises, how do we decide which interest should take precedence in this sort of a conflict? Should public safety take priority, or should a sacred, historical, indigenous sacred site? And if at some level we're balancing those interests, if that's what it means to have a constitutional right, that the judiciary has to balance the importance of that interest against whatever the government's interest is, we have to have an answer to the question of what is more important or more valuable than an indigenous sacred site or public safety. And as Justice Scalia famously quipped, that's like asking whether the length of a string is longer than the weight of a rock. There's not an answer to that question that is required by reason, which means that the answer to that question is subjective. The judiciary's answer to that question is as good as anyone else's. Doesn't leave litigants with a lot of predictability, and I think more importantly, if we're thinking about the normative criteria of democratic principles, it results in a democratic deficit where we're allowing subjective determinations on important moral issues to be determined not by a democratically accountable body. So even though there's a strong gravitational pull towards a balancing model of rights, I was trying to think about, is there a way of conceiving of rights that doesn't require us to offer a model that has this democratic deficit? Of course, Dworkin has famously proposed rights as trumps, but Joseph Raz argued that his model really devolved into nothing more than balancing, maybe with a heavier weight on the scale in favor of rights, but nothing really analytically distinct about that. Of course, we could go the Thayerian approach and say that in the context of the Native American sacred site conflict, we should just defer to the political branches, and the judiciary should have no role. And so if the political branches decide to protect the Native American sacred site, terrific. And if not, then the sacred site gets destroyed and the tribal elders are out of luck in that case. In other words, the political branches would have the only role in protecting rights, and there would be no role for the judiciary. And in contrast to the balancing mode, the balancing model really views the judiciary as having the only role in protecting rights, and the political branches as being in the frame of interfering with the right as much as the judiciary will permit them to do. There have been other scholars who have offered other proposals, including taking a more categorical approach to rights, exclusively categorical. And so, for example, in the Bruin case, we saw this sort of approach on display with a historical analog approach, where we look to see whether or not there's a historical analog of a government regulation of this type of interest, in which case the government is permitted to interfere with the right moving forward. And there's not really a question about the weight of the government's interest or evidentiary questions. It's more, what's the level of generality we're identifying for whatever the government did historically. So if we think about that in the context of the Native American sacred site, there's certainly history of government destroying those sorts of sacred sites since before the founding. Our government has been desecrating and destroying Native American sacred sites since before this nation was born. So does that mean that in any conflict like that, if we took a historical analog, categorical approach, that the government should always win and that the sacred site should always lose, no matter how unimportant the highway widening project or how significant the sacred site? I think categorical approach to rights has an important role. I think that's an important tool in the toolkit. But what I argue in this piece is that I think we would run into a zero-sum game and overall less protection of rights if that was the only tool that we had in the constitutional toolkit. So what I offer instead as a model of constitutional rights is what Joseph Raz refers to as a protected reason. That means that there's both a first-order reason for protecting a right and a second-order reason or exclusionary reason, meaning some reasons for interfering with the right are off the table. And one argument I make in this paper is that I think that the first-order reason, which does involve balancing, is something that is most appropriately handled by political branches when they're trying to decide what do we think is more important in this particular context. And the exclusionary reason is better policed by the judiciary. That's a lot of abstract language. So what do I mean by that in concrete terms? If a professor is trying to decide what grade to give a student, the professor might be weighing students' class participation versus a grade on this test and considering these different factors, and those would all be relevant things to consider when you're trying to come up with a total grade. There might be other reasons, though, that we just view as irrelevant and hopefully off the table, like if the professor thought a student's clothing style was particularly poor. Even if the professor felt really strong about that and hated the clothing style, it's sort of like there's a stop sign that just prevents some reasons from receiving consideration at all. And I think that constitutional rights that the judiciary is policing often are operating in that way. So why is this relevant? I think for the United States, there are two problems with how the Supreme Court has been approaching constitutional rights that I worry about if we adopted this sort of model of constitutional rights. One is that there are some justices on the Supreme Court who have equated strict scrutiny with judicial balancing and have suggested that any time the court is engaging in strict scrutiny to protect constitutional rights, then that's a form of illegitimate balancing and a reason we should move away from strict scrutiny. I don't think that that's necessarily the case. I think what strict scrutiny really is doing is preventing some interests from being reasons the government can rely on for interfering with a constitutional right, and then imposing an evidentiary burden on the government to prove that it was relying on a non-excluded reason to interfere with that right. What does that look like in the Native American sacred site case? Let's assume, for the sake of discussion, that with the constitutional right of free exercise, one of the reasons that is not excluded, but that is permitted to limit religious exercise is public safety. And that's what the government's claiming in this case. We need to widen the highway so that we can reduce highway accidents. So the government has asserted a permissible reason, and frankly, in litigation, I think government usually does. That's not where the rubber meets the road. Where the rubber meets the road is the evidentiary question of, is the government's action necessary to advance that permissible reason? Because if not, we should be suspicious that maybe that's not actually the reason on which the government is acting. And in that particular case, a real case coming out of Oregon, the government could have widened on the opposite side of the road, never had an answer to why the government wouldn't widen on the opposite side of the road. Went forward with the construction program anyway, destroyed the sacred site, and admitted on appeal that that destruction was unnecessary. That's a different question, though, if we're asking, was it necessary for the government to destroy this sacred site to reduce car accidents? That's a question that the exclusionary reason asks us to focus on and that strict scrutiny asks us to focus on. That's different than asking the unanswerable question of what is more important, a Native American sacred site or the lives saved when we widen the highway. And I think that the Supreme Court, some of the justices, have been wrong to equate the former with the latter. The other thing that I'm concerned about with some of the Supreme Court's jurisprudence it's illustrated in different contexts, but I think Section 5 of the 14th Amendment is a good example, where the Supreme Court has sometimes suggested that it is the only branch of government that ought to have a role in protecting constitutional rights. I'll bracket some of the federalism issues or the Commerce Clause issues in that context, but cases like City of Bernie are a good example, I think, where the court has taken this view that it is claiming the territory of protecting constitutional rights and not giving Congress the ability to weigh first-order reasons about rights in ways that might lead Congress to want to provide additional protections beyond what that minimal exclusionary reason would require policing by the judiciary. And with that, I'll go ahead and pause. Thank you.
Thank you. Exactly on time. And John.
Thank you. I realize that in providing comments on some junior scholars, I'm performing a function that in recent years has been performed by Richard Epstein, and I understand that I am no Richard Epstein, but I am going to demonstrate that I'm not a junior scholar by saying that thinking about that put me in mind of a X-Men comic book that I read back in the 1970s when I was in high school, and there's been some sort of disaster, an alien invasion or something like that. The U.S. military is on the scene, and they've called for superhero assistance, and the X-Men go, led by Cyclops. And Cyclops is in communication with the major who's in charge on the scene. And the major says, "Is this the Avengers? Am I talking to Captain America?" And Cyclops says, "Sorry, Major, the Avengers couldn't make it. We're the X-Men." Well, Richard Epstein couldn't make it, and neither could the X-Men. So I'm here. The first thing I'm going to say about Stephanie's paper is that I'm not sure at all that constitutional rights is a single category. And I'm going to break it down in along a couple of dimensions. One, the kind of constitutional rule that gets called constitutional rights. I think there are important differences among constitutional limitations that protect rights of property and contract, which dominated American constitutional law for a long time, constitutional rights that protect conduct, which is basically speech and religion, which I think is mainly what Stephanie's talking about. I tend to think those are separate categories. And then there's the third category of anti-discrimination rules. And I'm not sure that the principles that apply to one apply to the other. The other thing I want to make sure to say, because this is sort of the lead-in to the main thing I have to say, is that I think there are important differences in the application of constitutional limitations in their primary operation, which is as constraints on the content of legal rules, and in other situations, like, for example, administrative decisions, like the example of the road widening that Stephanie was giving. Having said that, I'm going to pause briefly and say about, since I'm a fan of City of Bernie and at the same time a longtime opponent of judicial finality, I'm going to say that one should read City of Bernie without Justice Kennedy's delusions of grandeur about the role of the courts and understand that it is about Section 5 and federal power and not about the courts have the last word about the Constitution. The main thing I'm going to say, and this is primarily about situations in which constitutional limitations, call them constitutional rights, constrain the content of legal rules, is that I'm not sure that it's possible to pull apart, and I think Stephanie wants to pull them apart, to pull apart the use of purpose analysis and whether rules are valid or invalid at rule level, sometimes called facial, or as applied. I think I totally agree with Stephanie that constitutional rights analysis routinely turns on considerations of purpose. That's right. I think that's right both in principle. It's certainly right in practice. My point is that purposes operate at the level of rules. Purposes legitimate generalizations. Rules are generalizations. And so purposes and purpose analysis do not fundamentally operate at the level of application. The question is whether the rule itself serves a permissible purpose or serves an impermissible purpose. And one of the most interesting pieces of scholarship about constitutional limitations in the protection of liberties of conduct in the last few decades, Elena Kagan's article about the First Amendment speech and press protections say that the heart of the constitutional doctrine about the protection of speech and press is an impermissible purpose, what she calls ideological opposition to the speech. That, I think, captures a great deal about constitutional analysis, both as it happens and, I would say, as it should happen. That is a purpose-type analysis. One of the things that Professor Richard Fallon, writing about this, has pointed out is that an impermissible purpose leads to rule-level invalidity because the purpose of a rule pervades the rule. The purpose is the reason for the rule operating at some level of generality, not just at a single case. Conversely, I think it's also true, and it's easy to lose track of this, but I think this drives certainly my basic idea of why I think Smith is fundamentally right, that there's a body of rules, Smith called them general and neutral rules, that are permissible and constitutional per se, just as there are rules that are unconstitutional per se, which are those that rest on an impermissible purpose, as then Professor Kagan pointed out. There's a body of rules of which the quintessential example are ordinary private rights. No private people who want to conduct religious activities do not have a constitutionally granted right to use somebody else's property to conduct the religious activity because the rules of property and contract, the private law, and I would say a whole lot of other law, being general and neutral rules, being driven by purposes that are entirely permissible or not impermissible, are at rule level constitutional. And they are constitutional, and this is the point of Smith, they are constitutional even in the situations where their application in a particular case imposes what the courts these days call a burden on some kind of protected activity. I think that's right. I think that constitutional law, the legal system, reflects both rule-level unconstitutionality, rule-level constitutionality, all of which is about purpose, which Stephanie focuses on. And here's the problem, that the situations in which rules are found to be unconstitutional in their application, as opposed to either constitutional per se or unconstitutional per se, are situations in which balancing takes place, in which somebody decides whether the burden that the general rule imposes on some kind of activity, even if it is pursuant to a permissible purpose, because if it's not pursuant to a permissible purpose, the rule is unconstitutional per se, even if it's pursuant to a permissible purpose, is it nevertheless constitutionally inoperative because of the weight of the burden that it imposes, comparatively speaking, on the person who wants to engage in the protected activity. So it seems to me it's not an accident that balancing and application level challenges, as opposed to either rule level challenges, rule level unconstitutionality, rule level constitutionality, go together. So I think it's going to be hard to pull them apart and to say that it is possible to have rule level application level unconstitutionality without engaging in balancing, which is, I think, what Stephanie wants to do. Because I think generally analysis of rules is going to find that there is a permissible purpose, and then the government's going to be able to do what they want to do.
Thank you. Thank you, John. Stephanie will get a chance to respond to this later on. But we're moving on to Tyler Lindley, who is going to explain his paper, Interpretive Lawmaking.
Great. Thank you, everyone. Justice Brandeis said it was a fallacy. Naive, admitted Justice Scalia, and a brooding omnipresence in the sky, derided Oliver Wendell Holmes. For nearly 100 years, these criticisms have been levied against the idea that there can be a body of unwritten law that judges can find and apply as much as they do written law. On the conventional theory, all unwritten law is not. It's either written in judicial decisions, and thus judge-made, or it's not law because it's not written. And that frees common law judges to, as Justice Scalia said, play king, devising out of the brilliance of their own minds those laws that ought to govern mankind. But the logic doesn't stop with common law areas. Even when legislatively enacted written law applies, judges can fill in the gaps and supplement that law with their own. And when statutes are indeterminate on a question, judges can choose, subject to loose due process limits, what content to supply to fulfill the purpose of the law and achieve good policy outcomes. And as I'm sure all of you know, Erie's logic and the propriety of judge-made law have been challenged on many grounds. But what if beyond being unreasonable and resting on a shaky foundation, judicial lawmaking was not constitutionally allowed in any context? It's not as crazy as it might sound, or maybe after I explain it, you'll still think that it is as crazy as it sounds. But if finding law is possible, and judicial lawmaking was antithetical to judging in 1789, then perhaps it's just a matter that the federal judiciary never received the power to make substantive law. Steve Sachs has explained that judges can find customs in the relevant population, much like grammar, fashion, and spelling. And it's true that these aren't judicially enforceable, but that doesn't make them any less real. When I tell my son that he's misspelled a word, I'm not making that rule as I tell him. I might be applying it in my role as his dad, but I'm not. But no one gave me that power to make it. I can't point to conclusive language kings that have made it before. And sometimes people even disagree about the correct answer within certain limits. In my view, judgment has a second E, gray has one, and silent letters don't belong in donut. But I think we can all agree that they don't have X's or Y's, or Z's, Gray does have a Y. Founding era jurists thought the same about unwritten law. Start with the common law. In 1793, Justice Iredell said the distinct boundaries of law and legislation must not be confounded in a manner that would make courts arbitrary and in effect makers of new law, instead of being, as they certainly are, expositors of an existing one. In 1871, Republican and Democrat senators agreed to what they thought was an apparently uncontestable proposition that courts do not enforce laws that are not made by the legislature, nor recognized as law being the common law of the state. Legal treatises as late as 1891 and 1907 agreed that it was unquestionable that decisions do not constitute laws but are most evidence of what laws are. Equity was no different. Blackstone explained that chancellors don't rise above law, but rather the equitable principles were founded on the same principles of justice and positive law as the common law. Other scholars from the late 1800s confirmed the same, that courts of equity at the founding considered themselves to be tasked with applying the same body of substantive rules as ordinary laws of the land. Even post-Erie, courts today sometimes purport to find law. Neither customary international law nor the law of other sovereigns is made by U.S. courts, but rather at least purported to be found and applied. So for example, this term, the Supreme Court is considering the enforceability of choice of law provisions in maritime insurance contracts. The opinion's pending, but oral argument focused on the customs of the seafaring, the land-bound excluded, but they didn't discuss what law the court should make. The same applied when interpreting statutes at the founding, if not even more so. Justice Story explained, writing circuit, that Congress could prohibit manslaughter, murder, and perjury, but without defining those terms in the statute, courts would have to look to their common law meanings. Otherwise, he said, the judicial power would be left in its exercise to the mere arbitrary pleasure of judges to an uncontrollable and undefined discretion. That is, judges would have to make law. Justice Washington said the same when construing a statutory prohibition on making a revolt. He had an intuitive definition, but he refused to apply it. Neither common law nor admiralty nor the civil law provided a definition, and the linguist's definition were so multifarious, he said, and would change the outcome of the case, such that choosing one or the other would be legislative. It's probably too aggressive a claim to say that the judicial power in Article 3 itself, those terms, somehow incorporated and requires a specific kind of judging. But our government has only enumerated powers, and those few powers necessarily bound up in them. So if the judiciary received the judicial power in Article 3, but if that power didn't include a power to make substantive law, then perhaps the judiciary never received it. Perhaps, at least to me, the most compelling argument against judicial lawmaking is the tension it creates with the constitutional structure and fundamental legal principles at the time of the founding. On Chief Justice Marshall's account of judicial review, judges sit as neutral arbiters, setting aside lower law to apply higher. The legislature couldn't, of course, determine conclusively the constitutionality of its own laws. There was an inherent conflict of interest, and all three branches must have concurred in the constitutionality of a new written law. But judicial review of judge-made law exacerbates that conflict of interest and bypasses the safeguards of the legislative process in the Constitution. So regardless of the desirability of judicial lawmaking, the Constitution doesn't seem equipped to handle this kind of power grab. Two important counterarguments. First, courts could make procedural law, but that power didn't extend to substantive lawmaking, which makes all the difference. Some procedural law was actually unwritten law itself, think abstention, preclusion, stare decisis, but courts did make a narrower set of rules. These kinds of rules were those that were necessary to decide cases, but not defined by unwritten law. And it's unclear whether they viewed this procedural lawmaking power as part of the case-deciding judicial power, incidental to it, inherent in it. But regardless, that lawmaking power was severely cabined. Even long before the founding, court-regulated process was guarded by Parliament, which was jealous of all that looked like an attempt to legislate substance under the guise of regulating process. Another objection, perhaps Congress can delegate its lawmaking power to the courts, but I think that argument fails as well. Even if Congress can delegate to the executive, it doesn't follow that it can delegate to the judiciary. Arguably, unlike legislative delegations to the executive, don't want to make Ilan mad, there is no deep tradition of similar delegations to the judiciary. It also makes hash of the structure of judicial review, as I have discussed. And Congress can dilute the judiciary's own power of judicial review by enlisting them as lawmakers. As one early 20th century treatise put it, courts may not be required, nor have they the right to exercise non-judicial powers. Once we reject Erie's intellectual grounding and break free from its shackles, I think we can better understand the founding era judicial role, at least as it was envisioned. And from an originalist perspective, we could see what that would look like in practice today. First, courts make law when they think a federal statute is defective and new rules are necessary to protect federal interests. But there's no defective exception for judicial lawmaking. Courts should leave to Congress to decide whether their statute is in fact defective and what to do about it. Second, anti-vagueness principles are deeply rooted in Anglo-American jurisprudence, but it's unlikely that they're a part of due process. Rather, I think that they're better understood as anti-judicial lawmaking and anti-retroactivity principles. Courts today, I think rightfully wary of expanding substantive due process, are stingy in their application of vagueness doctrine. As Justice Scalia said, I doubt that any modern court would go to the lengths described by Blackstone to avoid vagueness in criminal statutes. But returning vagueness to its anti-judicial lawmaking and anti-retroactivity roots provides a textual and more grounded basis to seriously enforce vagueness principles. Third, substantive canons. True, some of these canons might be law themselves, or at least form the backdrop against which Congress acts, and some might be required by the Constitution. But putting those aside, new substantive canons that are aimed to achieve policy goals are no different than supplanting Congress's law with a judicially preferred one. Finally, what about statutory construction zones that has been sometimes brought up? Well, there are two types of construction. One is applying law to facts, the act of adjudicating, resolving a dispute. It's true that in some, maybe Hans Kelsen, HLA Hart have said that's lawmaking. But as John Harrison and Caleb Nelson and others have noted, it's different in kind. It's at most a subsidiary kind of lawmaking. And for the founders, applying law to facts, even new facts, was permissible. The other version of construction, though, allows judges to fill textual gaps or give additional content to underdetermined statutes. But I don't think gaps or indeterminacy justify judicial lawmaking if there is no written law to apply. If there is no written law or unwritten law or state law, then judges should simply say so and resolve the case through burdens of proof or tie-breaking rules and step aside. I think in the end, judicial lawmaking conflicts with our ideals of separation of powers and disdain for retroactive legislation. But more, the Constitution doesn't allow it. Judicial lawmaking, at least in the outward sense that I've described it, obviously there are close lines and it's not an easy line to draw, but the outward judicial lawmaking reflects a worldview in which judges must resolve society's problems. It started with unwritten law, then statutory law, and it spilled into constitutional interpretation, where all the country's contested questions must be resolved at the constitutional level, as long as our preferred judges are making the decision. Maybe that way of thinking is correct. I'm skeptical, but if it is, we ought to craft a system that allows for and accounts for such lawmaking, because our current Constitution doesn't seem set to do so. Thank you.
Thank you. And we turn to John again for commentary.
Thank you. I get a break at some point. Well, I think today I've come to split rather than to lump, because just as I'm not sure constitutional rights are a category, I'm not sure that judicial lawmaking is a category. I think that there are, I'm going to say 3.5 things that people tend to talk about under the category of judicial lawmaking, and one of which Tyler was mainly concerned with. One is when courts make decisions based on their own views of sound policy. The second is where courts make decisions without any pre-existing law, written or unwritten. As they would say today, fashioning, for example, I love that word, fashioning federal common law as if they are creating it ex nihilo. People often talk about that as a form of judicial lawmaking. I don't know whether anybody thinks that's legitimate. I hope my tone of voice indicates that I don't think that's legitimate. Third, courts make law in a very meaningful sense when they operate within a system of precedent and when they are the precedent-setting court. But there, the judicial lawmaking results from the operation of the system of precedent. I said 3.5 because the half is going to be when the courts are given power, like under the Rules Enabling Act, to actually adopt some text that itself is then going to function like a statute. I think that, as I say, that Tyler is mainly concerned with the first category, the danger that the courts will exercise, what was it, uncontrolled discretion. Iredell didn't like uncontrolled discretion. I think when he talks about filling in statutory gaps and fixing defective statutes, maybe some of that fits in the second category. There wasn't really any law there to begin with, and the court made some in a very strong sense. But I think the primary thrust of the paper is about the first conception of judicial lawmaking, that is, courts deciding what they think is a good idea. People tend to run categories 1 and 2 together because, well, legislatures make law ex nihilo based on what they think is a good idea. And when courts do something like that, maybe they're doing both of those things and they're engaged in judicial lawmaking, underlining the point that judicial lawmaking is a metaphor, a figure of speech, and so has to be approached with care. The main thing I want to say about that, situations in which courts make their own policy decisions, is that sometimes what if the content of the law is such that they have to make policy decisions? I'm not going to call this delegation from the legislature. For example, what if it is true that the content of, say, the common law of contract is whatever principles best, I stress the word best explain and justify. If this sounds Dworkinian, it should sound Dworkinian. Best explain and justify what people do and what courts have done in the last several centuries. A judgment like that requires what we would call policy judgments, and yet that is built into the content of the law. By hypothesis, the content of the law is not freedom of contract. It is not even efficiency. It is something more abstract than that. It is whatever is best, whatever is right. Maybe the same thing is true about, for example, the freedom of speech and the free exercise of religion. That those are practices like the common law, the actual content of which is whatever principles best justify and explain what has been done for hundreds of years. Maybe, I mentioned Ronald Dworkin, I'm now going to bring in someone who did not like Ronald Dworkin, which is Robert Bork. Maybe restraint of trade is like that. Maybe restraint of trade is that kind of concept. Whatever principles best explain and justify what has been done under the common law principle that restraints of trade are unlawful. All of those situations are situations in which it's possible to say, yes, this is the content of the law. This is what the courts are working with. And yet, in order to find that content of the law, because it is that kind of principle, has those normative principles built into it, it's necessary for judges to engage in what we would call in the 21st century judicial lawmaking.
Thank you. We'll turn now to Caleb Griffin and his paper, The Waiting Game.
All right. Hi, I'm Caleb Griffin. I'm here to talk about my project on index funds and their market impact. So for this project, I wanted to explore how index funds change the markets that they purport to track. So I'm going to argue that index funds impact the market in significant ways, and that an important mediator of this impact is their weighting strategy. So in some ways, this paper is an extension of the literature on the extent to which index funds are truly passive. So some people might say, I think there's probably three dimensions that we can look at that. So governance is probably the primary dimension we've looked at it. Are index funds too passive? They lack adequate incentives to engage in good stewardship. Are they too active? They're effectively voting on things they have no expertise. So there's been a ton of attention in the corporate governance literature to that aspect. Growing attention has been paid to, are index funds passive with respect to portfolio composition? So are they simply buying stocks on a list in a purely passive way, or do they in fact have so much discretion that calling them passive is a misnomer? So Adriana Robertson and others have done a lot of work in this area, and it's received, I think, increasing attention lately. The third dimension, and the one I want to focus on today, is whether index funds are passive in their effects on the overall stock market. Are they merely tracking the market in a fully, purely passive way? Or are they also changing the market in important ways? In the legal literature, this dimension of passivity has received the least attention of the three, but I believe it's going to be very important going forward. So why haven't we paid much attention to index funds' market impact? Well, it probably made sense to ignore for a long time. 2 decades ago, the index funds were 2 or 3% of the equity market. Today, 33 to 39% of stock market assets track an index. Okay, so there's been really tremendous growth, and they've assumed a very central role in our equity markets in a pretty short period of time. How then are index funds changing the stock market? Well, first, there's evidence that they're decreasing the elasticity of the stock market, which is basically a measure of how changes in price influence demand. Most index funds, specifically those weighted by market capitalization, are extremely inelastic. So even if a stock's price shoots up really high, like GameStop or another meme stock that we saw a couple years ago, capitalization-weighted funds don't sell it off. Their mandate says, I've got to hold stocks in exact proportion to their market capitalization. So right now, that would be every dollar you put in an index fund in the S&P 500, about 7 or 8% of it goes to Apple. The top 5 or 6 companies are getting about a third of your 25 to 30% of your investment. So it's very heavily skewed, very, very concentrated in large companies. And so that's kind of the opposite of what a rational investor would do, right? A rational investor sees, I think this is overvalued. They sell. A capitalization-weighted index fund says, I will buy more in response to this overvaluation. So it's sort of the inverse of what a rational, traditional, elastic investor would do. When we look at, sort of zoom out a little bit and look at the stock market as a whole, we would measure this effect as total market elasticity, and it's measured as the size-weighted elasticity of market participants. Index funds now account for more than a third of the equity market, and so they're having a really large impact on total market elasticity, and that impact in large part is to reduce this elasticity relative to other investing strategies. when that happens, flows within the stock market, into the stock market, and sort of intra-market flows can have very large effects on stock prices because inelastic investors are loath to change their position. They require sort of greater inducement. So in summary, capitalization index-weighted funds are making stock prices more sensitive to demand. So that's the first impact. The second one is increased volatility. So by reducing total market elasticity, index funds are sort of directly increasing volatility. That's kind of the first mechanism because it makes stock prices more reactive to various shocks. The second one is that index funds increase what's called co-movement of stocks, trading commonality, essentially. So even if there are some differences in their holdings, if you're a market-weighted index fund, a capitalization-weighted index fund, you're going to trade much more synchronously than other types of investors, because you're basing your purchasing decisions on very similar factors, primarily the size of companies and whether they drop in or out of an index. So increased volatility is a second market impact associated with the rise of index funds. In addition, a number of studies associate the growth of index funds with stock price changes, and specifically they tend to link capitalization weighting with increased stock prices. Now that doesn't sound so bad at first, right? Everybody likes increased stock prices, but there are some reasons to be concerned. So first, this increase may be quite selective in that the biggest firms in the economy experience the biggest stock price increases. So one study estimated that the 50 largest firms rose by 30% more than the overall market due to index fund flows. So index funds may be actively providing what I call a subsidy to scale, causally making large firms even larger. And this in turn has a number of negative consequences for the broader economy, including industry concentration, reduced competitiveness, capital misallocation, and lower aggregate productivity. And second, even though stock prices have been boosted by index funds in the past, they might not actually be delivering higher expected returns in the future, which has some important distributional effects in that it's good for people who already own these stocks, but it's less good for people who are still building their equity portfolio and who don't have much invested in the market. So far we've seen that index funds are causally changing the stock market. Now let's turn to my second argument, that this impact is mediated to a significant degree by weighting strategy. Now an index fund weighting strategy, it's a mechanistic rule for how much of individual securities an index fund will buy. By far the most popular weighting strategy is based on market capitalization. So funds weighted on market cap have very low turnover. They just sort of accept the market weight as appropriate. They sort of defined away the problem, essentially, of index fund rebalancing. And they don't need to buy or sell when stock prices change. So tying this to the impacts we mentioned above, because these are among the most inelastic investors in the equity market, the elasticity is basically zero. They're directly contributing to that inelasticity that we mentioned, the aggregate inelasticity. They're also increasing volatility for some of the same reasons, including co-movement. And some of the price effects, like the overvaluation of large firms, are directly tied to this weighting strategy in particular. In contrast, other types of index funds don't impact the market in the same way. So in the paper, I go through a bunch of different types of weighting strategies. I'll just talk about two of them today. Sigh of relief from the audience. So the first is equal weighted index funds. As the name implies, they hold stocks in equal proportion. So they're actually highly elastic. So some of the most elastic investors in the equity market, sort of countering the inelasticity of market weighted funds, they're very sensitive to stock price changes. If a stock price goes up, under its mandate, an equal weighted fund will have to sell to maintain sort of its equal proportion of every stock. And so they're countering some of the market impacts associated with capitalization weighted funds. Now, I'm not saying we should all switch to equal weighted funds. I'm not saying that they're better or more profitable. It's just that they are offsetting one another because the effects are opposite. Second, some index funds use financial weighting strategies, essentially creating financial metrics to weight their constituents. So you might say, we'll weight them by dividend yield or revenue growth, or oftentimes there's sort of a sophisticated combination of different financial metrics that they use. These are also more sensitive to stock price changes and other financial information, so they're much more elastic than capitalization weighted funds, and they don't contribute in the same way to things like increased volatility and potential price shifts. So index funds then are not uniform in their price impact. So if they have these different impacts, well, what's sort of the status quo? What are we looking at today? How common are the various types? Prior to this project, there really wasn't any good data on this question, so I hand-collected my own data on the various weighting strategies of index funds. I did about 842 all index funds and ETFs, a totally comprehensive view, about $7 trillion. I had a tremendous time looking at these. That was a joke. And I found that as a numerical matter, about 62% of them are weighted by market cap. But I don't think that tells the whole story. When you look at the assets under management of these funds, 93% of the index fund assets are weighted by market capitalization. So I think it's fair to say, when you look at the big picture, virtually all index fund assets, roughly 93%, are contributing to the market impacts we discussed earlier. So what is the significance then of this data for policymakers? First, I think regulators and policymakers should be aware of the potential for externalities associated with capitalization weighting. We've kind of assumed that index funds are purely passive in this dimension, and in many others as well, but there's evidence that they're actively reducing elasticity, they're potentially increasing volatility, and they're changing stock prices to a meaningful degree. So passive funds truly are not passive with respect to their market impact. And as a product of their market impact, index funds may also generate important harms to the broader public. They may be contributing to industry concentration, which harms workers and consumers. There are some common ownership concerns that I think are really interesting as well. They're contributing to potentially reduced competitiveness and capital misallocation. So there is perhaps a hidden cost to cheap index funds that we need to weigh against their obvious benefits. So there are important tax implications as well with respect to how do we tax and regulate ETFs and heartbeat trades, and what's the definition of a passive fund, how strictly should we regulate it. So these policies, I think, have a direct impact on the desirability of different trading strategies, and they can amplify or diminish the market impacts that we've talked about today. So in conclusion, I think we've sort of assumed that index funds could passively track the stock market without really affecting it, and I think that might have been true 20 years ago, but there's growing evidence that it's not true today. Thanks.
Thank you. We'll now switch commentators and give John a break and turn to Robert Miller.
So this is a very rich paper, and there's a lot of different arguments in it, and in my 8 minutes, I'm going to try to say probably two things about it. The first is, as Caleb quite correctly points out, the vast majority of money in index funds the money is in funds that weight their investments according to the market capitalization of the stocks. In the paper, Caleb suggests that this is a function of reduced trading costs, because if you weight by market cap, you don't have to rebalance very much, and you therefore don't have to trade, and you avoid brokerage fees, and you avoid tax leakage because you're not having realization events and so on. I don't think that's right. I think there's actually a really good reason that most index funds weight by market capitalization. And the first reason is this. If you're creating an index fund and what you're doing is tracking an index, you have to weight according to the weights that the people who made up the index use in making their index. If you want to invest in the S&P 500 and you put 1 penny in each of 499 stocks and all the rest of your money in Apple, you're not tracking the S&P 500 anymore. You're just tracking Apple at that point. All right? So the question is, why do the indices tend to weight by market cap? This is what the S&P 500 does. It's what the Russell 2000 does. It's what most of the indices that you see across the top of the Wall Street Journal. The only exception is the Dow, and that's because it was invented 150 years ago. So why is it that people who create indices weight by market capitalization? The index doesn't trade anything. It doesn't actually own anything. It's just a number that's computed. So it's not worried about trading costs. It's not worried about tax leakage. Why does the index weight by market capitalization? And I think there's a really good answer to that, which is that when you create an index, what you're trying to do is create a proxy for the market. Right? People use the S&P 500 as a proxy for the whole stock market, or they use the Russell 2000 as a proxy for the market for small cap stocks. And if you want to use an index as a proxy for the whole market or a section of the market, of course you have to weight according to market weights, because otherwise you're not tracking the market anymore. The market weights by market weights. So of course you have to track that way, you have to invest that way, or you're not tracking what you're intending to track. You're not creating a proxy for what you're hoping to create a proxy for. Right? And there's another reason, an even deeper reason, which is that the market portfolio, in other words, the collection of all the stocks in the market weighted by their market caps, the market portfolio is really important in corporate finance. If you look at, for example, the capital asset pricing model, the capital asset pricing model predicts that the return on any asset is the risk-free rate plus the beta of the asset times the difference between the market return and the risk-free return. The market return is the return on the market portfolio. So that portfolio's return is really important in pricing everything else. Similarly, in what's known as the separation theorem, no questions please, I only have 4 minutes at this point. In the separation theorem, it turns out that the optimum portfolio for any rational investor is a combination of the market portfolio and the risk-free asset. Holding anything else is demonstrably irrational if you're interested in maximizing profits. So having the market portfolio out there is really important for theoretical reasons. And if you want to use any investment strategy that refers to those theoretical reasons, you need a proxy for it, whether it be the S&P 500 or anything else. And any proxy index fund that wants to track the market portfolio has to use market weightings. So this is not an artifact of transactions costs or taxes. I think it's like there for really important reasons, which is why 93% of the money in index funds are market weighted. So that's I think the first point. It's more important than just an artifact of transactions costs or taxes. The second thing is that I'm a lot more skeptical of the evidence that Caleb reviews that comes out of the financial literature, that index funds really have these effects. So one of the studies that Caleb mentions is this paper by, who are they? Jiang, Vanawos, and Zhang. The paper is actually being presented today at an American Economic Association meeting. But it's been up on SSRN for a couple years. It's not been published. It's not been peer-reviewed. This is the study that claims that index funds have caused the 50 largest companies in America to increase in price over the last 25 years, 30% more than the general growth in the stock market. Right? In other words, this is the claim that the index funds are inflating the value of the largest companies. So I said 30% of the 50 largest companies, that must be a hell of a lot of money. So I started running some numbers. If this is correct, then the implication is that those companies as a group, the 50 largest companies, are overvalued by slightly over $6 trillion. That would mean larger than the market value of every company in the world, taken singularly, about twice of Apple, about 5 times of Google, okay? This is a lot of money. It would be 22% of the annual GDP in the overvaluation of just 50 companies in the world. By comparison, the amount of money in index funds is also about $6 trillion. So the claim these finance guys are making is that by putting $6 trillion in index funds, we've caused a $6 trillion overvaluation of the top 50 companies. That can't be true. Right? That just cannot be true. It is way too high. And if you dig into this paper and you see how they compute this number, they do a regression analysis over by a quarter-by-quarter basis over their 25-year period. They get a certain value in the regression, and then they assume that the effect, as shown by the regression, is the same over all 99 quarters in their 25-year period. But now think about that. They're claiming that the index funds are having the same effect every quarter, on average, for 25 years. 25 years ago, there was no money in index funds. The effect back then can't be the same as it is today. So that would have to mean that the effect back then was small, but today it's utterly gigantic in order for the average to be the way that they say it should be. That can't be right either. And when you look into how their model works that the prices are being driven up by increasing the volatility of these stock prices. And again, no questions, please. But that wouldn't make any sense if in pricing the model, pricing the stocks, you use the supply side equity risk premium rather than the historical risk premium, because the supply side equity risk premium should factor out demand side changes in prices. So that shouldn't work out that way if you use the standard supply side ERP, as far as I can see. So I would be more skeptical of what these finance guys are telling. And I got a couple of others examples when I dug into the papers, and I said, that can't be right. So I think it's an interesting area of concern, but I think we need to see how the evidence develops, and it's probably not going to be, in my view, as likely to be as big as some of the numbers are suggesting. So that's what I have to say.
Thank you. We'll turn back now to public law with a presentation by Chad Squitieri, who's going to tell us about administrative virtues.
Great. Well, thank you very much for the organizers for having me here, and it's particularly great to have some comments by John Harrison, who I had the privilege of taking, I think, 2 courses at UVA Law. So my paper is called The Administrative Virtues, and it proceeds in 3 parts, so I figure I'll proceed along the same 3 parts in my talk today. So part 1 is called Introducing Virtue Ethics, part 2 is called Embracing Virtue Ethics, and part 3 is called Applying Virtue Ethics. So starting with part 1, Introducing Virtue Ethics, what is virtue ethics? What are these administrative virtues that are the subject of my paper? And essentially, virtue ethics is a third alternative moral framework that stands an alternative to 2 more dominant moral frameworks, deontology and consequentialism. And I wrote this part of the paper for individuals that might think, well, what in the world does moral philosophy have to do with administrative law? And my goal in this first part is to show that, well, the deontological and consequentialist perspectives have had a tremendous influence over administrative law as we know it today, which I think opens the door to considering the third alternative, virtue ethics, which most scholars haven't paid as much attention to. So what is deontology and how has it had influence? Well, deon refers to duty, and the idea is that morality is judged based on looking at actions. So one has particular duties to not do certain things or to do certain things. So one might have a duty to never tell a lie, to always tell the truth, even when telling a lie in a particular circumstance might lead to very good consequences. And I think we see the deontology's influence in what's called administrative common law, which is a collection of judge-made cases that place restraints on agency action. And these restraints are difficult to tie to particular statutory or constitutional provisions, save for fig leaves offered by the Due Process Clause or the APA's reference to arbitrary and capricious action. And in this part, I build on work by Professors Cass Sunstein and Adrian Vermeule, who I think have demonstrated persuasively that what holds these various cases together is a commitment to Lon Fuller's 8 failures of law. And I build on their work and therefore show that when Fuller is talking about those 8 failures, he's referring to a morality of duty, and therefore this administrative common law is best understood as placing deontological constraints on agency action. Now, what about consequentialism? I think for administrative law scholars, this might be more obvious to recognize the influence of consequentialism, which tests morality by looking at the consequences of particular actions, right? Doing more good consequences than bad consequences. And we see consequentialism's influence over administrative law in the executive branch, where executive officers, often White House officials, will subject regulations to cost-benefit analyses. Essentially, the idea being here that the good thing to do, the moral thing to do, would be only issue those regulations for which there are net benefits, more benefits than cost. Virtue ethics is, again, a third alternative. So whereas deontology focuses on actions and consequentialism focuses on actions' consequences, virtue ethics looks at the actor, him or herself. So the idea is to figure out what characteristics, called virtues, would assist an actor in performing their function, whatever that might be, excellently. So if we imagine a situation where an administrative official might have the legal authority to do X, Y, or Z, what should they do? Well, a deontologist might say that, well, you should always do X, or you should never do Y, because we have rules against that. A consequentialist might say, well, let's test the X, Y, and Z, and go with the action that has the best net benefits. Now, virtue ethicists would take a step back, look a bit further, more upstream, and think through, how can we design the administrative state such that it is staffed by administrative officials who have the right characteristics, the right virtues to make a moral decision. So that's introducing virtue ethics. Part 2 is embracing virtue ethics, and in this part, I'm seeking to answer a question readers might have. Can I embrace virtue ethics, or do my jurisprudential commitments limit me from doing that? And to show that I think most readers can embrace it, I split readers into two broad groups, formalist and functionalist, because I think that gets to the heart of an understanding of what administrative power is. So formalist, of course, maintain that there must be a relatively rigid separation between legislative, executive, and judicial power, such that any exercise of administrative power has to be one of those. Functionalists are more willing to have a blend of those three powers. And of course, formalists are often an originalist or judicial conservative. Functionalists are often living constitutionalist or a progressive, though there are, of course, exceptions. The idea here is to show that whether you are a formalist or a functionalist, and thus by loose proxy, suspected of being an originalist or a conservative or a living constitutionalist or a liberal, that you too can embrace virtue ethics. So how can a formalist embrace virtue ethics? Well, I think a formalist can do so by recognizing that administrative officials play a distinct role that presupposes virtue. So what do I mean by distinct? Well, administrative officials are not Article III judges. So even if you're a formalist that thinks, oh, I don't want my Article III judges engaging in policy argument or a moral debate, administrative officials are different. We do want them engaging in policy decisions, and we do want them considering the morality of their actions. So what about the presupposition argument? Well, I argue that the structure of the federal government presumes that officials will have at least some virtue to not constantly be cheating and conniving. So to be sure, a guy named James Madison reminded us that men are not angels and we shouldn't base our Constitution on the hope that men are angels. But that same Madison reminds us that Republican government presupposes that there will be sufficient virtue among men for self-government. Otherwise, as Madison states, if there was, quote, no virtue among us, then the country would be in, quote, a wretched situation because, quote, no theoretical checks, no form of government can render us secure. So the idea is, yes, men are not angels. We need separation of powers. We need checks and balances to limit the occasion where we have to rely on our officials' virtue. But there will be occasion when administrative officials, perhaps in the dead of night, have to exercise discretion, and there will not always be an opportunity for another branch to be peering over their shoulder to make sure that they're not constantly trying to cheat, so to speak. What about functionalists? How can a functionalist embrace virtue ethics? Well, I think the case is a bit easier for functionalists. That's in part because many functionalists recognize that combining executive, legislative, and judicial powers together can be quite dangerous, but they argue, don't worry, it won't be that dangerous because we'll require these officials to act with a certain sort of professionalism, professionalized experts. And I think when you're looking at the character of an official like that, right, they'll act with professionalism, I think that opens the door to looking at the virtues, the characters of the officials more generally. And finally, part 3, applying virtue ethics. In this part, I seek to show, how administrative law might be the same or change if we adopted a virtue ethics framework. And to do that, I focused on what are referred to as the 4 cardinal virtues: prudence, temperance, justice, and fortitude. And for time here today, I'll just touch on 2 of those: prudence and fortitude. So prudence, sometimes referred to as practical wisdom, assists in choosing the appropriate means for pursuing particular ends. So administrative officials often have various means available to them to pursue a policy goal. So they might say, we wish to do X, we can do that via sub-regulatory guidance. We'll change our website language, for example. We might do that through a formal rulemaking, an informal rulemaking, and adjudication. Or perhaps we recognize that we need a new statute, so we'll help work with Congress, provide technical assistance to draft a new statute. A prudent official would know which of those means is most appropriate for achieving a particular policy outcome, which I think provides support for some existing aspects of administrative law, such as the Chenery 2 principle, which essentially says, yep, we'll defer to the agency to figure out if they want to do an adjudication or rulemaking, and then also the deference that some courts give agencies in finding good cause for the exception to the 553 notice and comment requirements. And the second virtue that I'll touch on today is fortitude. This is also sometimes perhaps more commonly called courage. I think the biggest source of danger in the modern administrative state is political danger, right? The danger that comes with making a decision, a policy decision, that is politically unpopular. So a focus on fortitude, I think, would require 2 changes. One, it would call for a reinvigoration of the non-delegation doctrine, which would require Congress to more routinely face political dangers themselves and make policy decisions in the face of those political dangers, and therefore be habituated to develop the virtue of fortitude over time. The second change, I think, would be to continue on down the path of the Supreme Court's recent presidential removal decisions, which by subjecting administrative officials to the political repercussions, good or bad, of their actions, it again provides more opportunities for those officials to make decisions in the face of political dangers and therefore have opportunity to develop the virtue of fortitude. So with that, I'll stop there. Thank you very much.
Thank you. Back to John.
Thank you. I guess I've been put in the position of coming out against virtue. I have two observations. The first is I was prepared to go along for a while because I've heard people talk about virtue ethics, and people who actually know things about ethics and about virtue I've heard say virtue ethics is a sort of a school, a theory, along with deontology and consequentialism. And so, because there are a lot of people who think like this, I think it's okay to say, yes, I'm going to talk within virtue ethics. People talk within virtue ethics. I had more doubts about the invocation of Aristotle. Nothing against Aristotle. But I think that it is well, I guess what I'm about to say, since it used to be said against Aristotle, maybe it's a little bit against Aristotle, which is when it comes to long-standing debates and issues that have been going back and forth for a couple of thousand years, one of the sort of anti-Aristotle things that I think people started saying 500 or 600 years ago, so I'm now going to put myself in the paradoxical position of adopting a position that I think was first urged centuries ago, the content of which is, we know more than people did centuries ago. The great formulation is, we are the ancients. We have vastly more experience here in the 21st century about what people are like, about how human beings operate in varying circumstances, about how different forms of political organization operate. That is true for us relative to Aristotle. It was true for whoever first said we are the ancients relative to Aristotle. It's true for us relative to the framers of the US Constitution. We have vastly more experience about how representative government under a written constitution works. When it comes to knowing about these things, we are the ancients. There's a phrase somebody used at the Federal Convention, we must go by the lamp of experience. Well, their lamp of experience was a candle because they had so little experience. We've got these bright lights that have been in our eyes for the last hour because we have so much more experience. The point there for Chad's paper is, as I said, I think it's one thing to say, yes, virtue ethics is a way of thinking about morality. It's another thing to use a structure that Aristotle came up with 2,400 years ago. Some of us, me included, need some persuading that there hasn't been a lot of progress on how to do virtue ethics, if you're going to do virtue ethics, in the last 2,400 years. We are the ancients. We should know somebody. We should know better. Maybe somebody knows better about what virtue looks like than Aristotle did more than 2,000 years ago. The other thing I want to say specifically about administrative law is that I'm not sure that the prescriptions are really all that different as among deontology, virtue ethics, and consequentialism. As for deontological ethics, say as applied in the administration of the administrative state or in judges making decisions about the administrative state, notice those are two different things. Both of them involve rule following, like deontological ethics, and both of them, especially what the administrators do, then involve making judgments within the boundaries set by deontological principles, because deontological principles and legal principles routinely provide side constraints within which judgment, prudence, something like that, has to be exercised. So I think that consequentialism and virtue ethics, or whatever is the best approach to how to make judgments that aren't controlled by a side constraint, don't conflict with one another, and don't conflict with one another in the operation of the administrative state. Similarly, what does consequentialism call for? Well, consequentialism calls for example, efficiency and rationality. It calls for using the resources that are available to the task in the best way to accomplish the task. That is to say, it calls for cost-benefit analysis. So does prudence call for cost-benefit analysis. And it may be, and here maybe I'm sort of doing some different forms of utilitarianism, it may be that consequentialism calls for the cultivation of the ability to make judgments under uncertainty. What is prudence? The ability to make judgments under uncertainty. Once again, I don't see a lot of conflict between consequentialism and I'm taking a very rough approach to what virtue ethics means because, as I say, I hope there's an improved version of virtue ethics since 2,400 years ago, but I don't know what it is. But I'm going to guess it includes something kind of like what Aristotle called prudence, which is the ability to do cost-benefit analysis under circumstances of uncertainty, as we'd say, in the 21st century. So they seem to me to be not alternatives, but complements to one another.
Thank you. We didn't know we were all ancients. Now we do. Ilan.
Great. Well, you made it to the very end. So thank you for staying awake, though I expect John and Robert's commentaries have kept us all wide awake. So my paper is called The Opinions Clause in Presidential Power. Originally, I just thought it was a small intervention that helped us make sense of the Opinions Clause, but I think I've solved presidential power. So there's payout for you having stayed here till the end. Okay, so more seriously, what I'll do, time permitting, is up to 3 things. First is I'll just describe what I think are the 2 prevailing conceptions of presidential power and why I think they're only half right, or they're both half wrong, and what I'm offering instead. Second, I'll take things out of order because I think it's more important before my time elapses to tell you the implications and why this matters, because to some of you it may seem like I'm splitting hairs. And if I still have time, I'll try to prove to you why I'm right, but I suppose we could figure that out later if necessary. Okay, so the one prevailing conception, I think, is the formalist originalist conception, which is that all executive discretion, all discretion granted by Congress, by law, to executive officers is the president's discretion to exercise. That by virtue of the removal power and the ability to direct and control officers, if duties are assigned to other officers, that's fine, they have to do it, but the president can control and direct those officers by virtue of the executive power and can enforce that at least through removal. The problem with this view is it seems to make the Opinions Clause superfluous, right? The Opinions Clause that grants the president the power to demand the opinions in writing from the principal officers of the executive departments relative to their duties. It's possible that it's not entirely superfluous, but it's hard to imagine that, because if the president, by virtue of the executive power, has the power to direct and control, presumably it's incidental to get information so that the president could do that. So it seems superfluous, and quite frankly, all the formalists and originalists accept that it is. They say, yes, it's superfluous, but so what? That's not the death knell to interpretation. Okay, so that's one view. The other prevailing view, I think, in the academy is this idea that the president is merely the persuader-in-chief. Now, to be clear, Richard Neustadt famously said that the president's practical power is the power to persuade, but these scholars elevate that to constitutional status. They say that the Opinions Clause is the only power that the president has in this respect to control administration. The president can demand opinions. The problem is, well, what is the president to do with that information? And they say things, well, it gives the president the power to cajole, to persuade, to mobilize the rest of the government. This is literally what Peter Strauss and others have said. The big problem here, I mean, it makes sense of the Opinions Clause, but there's no historical evidence that this is how the founders understood the president's role. Okay, they understood that the president would supervise the execution of the law, and that implies, I think, some more control, whether direction versus removal is something I'll get into. Okay, so I think both of these are half right or half wrong. Let's go with half right. I suppose that's more generous. I think the original conception of the presidency is that the president does have a power to remove, an uncontrolled power to remove, or uncontrollable power to remove. But the president does not have a constitutional power to direct and control officers. At least there's no constitutional right for the president to do so. So to be more precise, the president could always speak. Anybody could bloviate. Okay, we're all law professors. We know this to be true. Okay? The question is the constitutional obligation of the principal officers to obey the president. And my claim is they don't have such an obligation, that they have an independent duty to exercise discretion given to them by Congress, and they could tell the president to, go fly a kite. The only obligation they have to obey is to provide the president with information, to provide the president the opinions in writing about how they're executing their duties, so that if the president wants, the president can exercise this removal power. Okay, so what's the big deal? This may seem like splitting hairs. Well, point number one is it makes sense of the Opinions Clause, right? Because if this is true, the Opinions Clause is obvious work. It says, yes, Congress can give independent duties to principal officers, but they always must obey the president in this one respect, give the president information about how they're executing their duties so that the president may exercise this constitutional power to remove. But I think more importantly, there is a real difference, okay, between this conception and, say, Judge Naomi Rao's conception, where she says the removal power is necessary and sufficient to control, right? Her view is that the president has the right to control, and that the president can do this sufficiently through the removal power. My claim is there's no right of interference. Congress can grant that right, but there's no constitutional right of interference. So why does this matter? Because the political cost of removal is much higher than simply directing and instructing officers, and the cost goes up in a constitutional culture in which we believe the president does not have a right to interfere with those duties. The cost of removing someone goes up, okay, in that world. If you believe the president has a right to interfere and they remove someone because they're not listening to the president's instructions, then so what? Okay? And there are lots of examples, George W. Bush and the U.S. attorneys, we can come up with a lot of examples of this political cost, okay? I also think this allows for the creation of independent agencies. What makes them independent isn't the removal power, right, but this granting of independent discretion by Congress, and that our constitutional culture should accept that it is their duty to exercise that discretion. The president has this check. The president can always remove, but the political costs are high, and are higher under this conception. Okay, now what's the evidence for this? There are a few steps in the argument, so I'm not going to go through all of it. Step one, the president cannot personally execute the law in the absence of a statute. The executive power loosely is the power to oversee the execution of the law. Okay, what does this entail? At a minimum, the power to appoint and to remove, because remove comes from appointment. I do think I have an important intervention in the removal power debates here, but I'm not going to talk about that. Let's just assume that I'm right about that the president has free power to remove officers. Does that mean that the president gets to direct and control them in their duties? Turns out that a ton of people, like Thomas Jefferson, James Madison, William Ritt, George Washington, William Howard Taft, and Adams, Monroe, and some others, thought not. They thought the power to remove did not imply the power to control or interfere with duties of other officers. So the primary evidence is in 3 buckets. 2 of it is just settling accounts, legal claims against the government. And so, for example, James Madison, I question very much whether the president can or ought to have any interference in the settling and adjusting of legal claims. Thomas Jefferson, with the settlement of accounts at the Treasury, I have no right to interfere in the least. George Washington, my public situation forbids any interference in individual claims. This will be satisfactory for you for my declining to direct an investigation that you have requested of me. I have no power in interfering unless it be in the case of malpractice in the officer. This was also the case with inferior appointments. Often this was the Postmaster General was given the power to appoint deputy postmasters, and it sometimes came up whether the president should make the choice here, and several, William Wirt and others said, no, you're the Postmaster General, don't pass the buck to the president on this. Congress gave you the power to do it. Now they said, look, if you mess up, the president can remove you. So you can ask the president for advice, but the president can rightfully refuse. There's no right of interference, okay? And there's no constitutional obligation to obey. Now you may say legal claims, inferior officers are somehow different, but from the perspective of executive power, it's all executive power under the Constitution. And there are other examples that involve other situations. So the famous debate over withdrawal of Treasury deposits that between Andrew Jackson and Daniel Webster. Daniel Webster said, I'm not denying Andrew Jackson had the right to remove those 2 secretaries of Treasury for refusing to remove the deposits. But the law gave the duty to the Secretary of Treasury to conclude that the deposits were not safe in the Bank of the United States, and the removal power was abused. Yes, the president has the power, but it was abused in order to interfere with the Treasury Secretary's discretion here. Obviously, Jackson disagreed. Let me leave you with one final piece of evidence, and I made it with 1 minute to spare. Okay? The statutes creating the departments in 1789, the famous decision of 1789, okay? Formalists, buckle up. You love this statute, okay? In this statute, Congress avoided meticulously appearing as though it was granting power that the Constitution already granted. Okay? So the original draft said that the principal officer of the War Department and the Foreign Affairs Department shall be appointed by and with advice and consent of the Senate. They said, wait, the Constitution already does this. It'll look like we're conferring this thing. The Constitution already does it. They struck it. Whether the president had the power to remove the principal officer was the great debate, and they decided it was a matter of constitutional right, and so they bent over backwards to change the language into the passive voice whenever the said principal officer shall have been removed. So it didn't appear as though the Congress was conferring the removal power, okay? And yet, in this statute, we have this remarkable provision. The said principal officer shall conduct the business of the said department in such manner as the President of the United States shall from time to time order or instruct. So you're telling me they bent over backwards to avoid the implication that Congress was giving power that the Constitution already gave, and yet they do exactly that here. This, again, I think suggests that there's no constitutional obligation on the part of these principal officers to obey. All right, I made it through it all.
Thank you. John.
Thank you. I agree with Ilan.
Good, we're done.
But of course, since I have 8 more minutes, 7.5 now, the other half is going to be after. Nevertheless, I agree with Ilan that, of course, any understanding of Article 2 has to take into account the opinions in writing clause. Any account of Article 2 has to take account of all Article 2, and the opinions clause is in Article 2. Now, I am a Unitarian like Ilan, but I'm not the exact same kind of a Unitarian as Ilan or as a lot of other people are. I don't believe in a constitutionally mandated removal power or a constitutionally mandated power to give instructions. I think the Constitution is vaguer than that. It makes the president the chief executive and leaves to Congress how to implement that with powers like removal or a power to give directions or something else, and that Congress must act subject to the constraint that the president should be in charge. Now, that's the way I see Article 2. Different people see it differently, and I think it's easy enough to say from that standpoint what the opinions in writing clause is therefore, it is to give the president in the Constitution one tool that's potentially important, which is to say to important subordinates, you have to tell me what you think. You can't just say, you're the boss. You tell me what to think. And that, when you're talking about how high-powered people, department heads, is an important tool in addition to anything else Congress may enable the president to do. And having said that, I want to go on to say that I think that in understanding the kind of inquiry that Ilan's conducting, that I think it's necessary to conduct, which is explain all of Article 2, including the Opinions Clause, it's very important to understand that the government might have gone in very different directions, and the government over decades has gone in very different directions. For example, one thing about the Opinions Clause is, as Ilan reminds us, it's a source of information for the president. George Washington had no White House staff. George Washington did not have reliable sources of information, and the people at the Federal Convention looking at the chair and General Washington and thinking he was probably going to be the first president probably would have realized that he would have a bare bones administration, but he would have departments and department heads. And so on the assumption he won't have special assistants or chiefs of staff or anything like that, but he will have the department heads, making sure that the president can get reliable information on the basis of which to act could be a very important constitutional safeguard for the president being able to perform his function. The other really interesting thing that Ilan got me thinking about, and that's another explanation for the Opinions Clause, it's a direction in which the constitutional system could have gone, and again, I'm going to think about General Washington, but largely didn't go. Maybe a little bit now and then. And that's the situation in which the president's the president, the president's the boss, and some of the department heads are understood to be really important people, really heavy hitters. So imagine General Washington, who's the boss, he's not the king, he's accountable because he's the president and he's not the king. And his Secretary of the Treasury is Colonel Hamilton, who's a big deal person, who is known to be the country's leading authority in the public debt. It's really important to have Colonel Hamilton in the government, even though he works for General Washington, and everybody knows he works for General Washington. The Opinions Clause makes it possible for Washington to share accountability with Hamilton, not to pass the buck. Again, he's not the king, he's not allowed to pass the buck, but to use a phrase that I think Nancy Pelosi used at one point, to make sure that you are in the boat with me. She was given information about a highly controversial NSA program, so she would be in the boat. Well, the Opinions in Writing Clause makes it possible for General Washington to have Colonel Hamilton in the boat with him so that they can both be accountable. I think we tend to forget that in the highly presidentialist system that has evolved, that there's a lot to be said for the situation, and the framers could conceive of this, in which the department heads were important figures, in which being able to hold the department heads themselves accountable along with the president. I keep saying that because I'm a Unitarian. Along with the president was a very important tool because, to use Hamilton's phrase, they would think that fame is the ruling passion of the noblest minds. We know better than that because we're the ancients. But that remains an important motivator. The framers understood that. They understood the importance of accountability. That's another explanation for what the Opinions Clause is for, even though it's a function that the clause rarely performs. As I say, because of the strongly presidentialist direction American constitutionalism has taken, but that's the direction it happened to have taken, and it's important to see that the Constitution is more general than that. The Constitution makes possible different institutional arrangements, all of which are consistent with its fundamental principles. In some of those different institutional arrangements, the Opinions Clause has a much more important practical function than it does today. Any explanation of the Opinions Clause has to take into account those alternative possible institutional arrangements.
Thank you. Well, this panel has demonstrated exceptional virtue, whether ancient or otherwise, because they have all stayed within their time, which is really a remarkable achievement for a group of academics. So thank you all. And your reward is, paper presenters, your reward is that you get to respond to your commentators. So I'm going to give you about 2 minutes each to respond, and then we'll open it up for questions.
Well, thank you to John for his Avenger-level feedback. It was pretty terrific. First thing I want to say, I know a lot of water has gone under the bridge, but jumping back to constitutional rights as protected reasons, John stated in his comments that what I'm really arguing about is government purpose, meaning I think bringing to mind a subjective purpose government might have. Understandable that the word reason would bring that to mind. That's not what I mean. The word reason in the realm of practical reasoning, that sort of philosophy, and as Joseph Raz used it, means a state of affairs that actually exists in the real world that provides a normative justification for why we ought to take a certain action. So subjective belief isn't enough. It's often not a reason if a state of affairs doesn't actually exist. So you could just as easily substitute the word reason with government justification, government interest. That's what I'm talking about. So in terms of how that breaks down for the as-applied versus facial context, I think it has, the arguments I'm making have some real implications for how remedies would cash out in the constitutional context. One argument that I make as a matter of democratic accountability is that whoever the government body is that is responsible for the interference with the constitutional right they're the ones that need to offer the reason that is not excluded and then demonstrate under the evidentiary burden that that's what they're advancing. So if the statute itself doesn't necessarily cause the burden on the constitutional right, we're not looking to Congress for the reason. We're looking to the government official who's applying that law. If you think about, again, going back to the Native American sacred site context, the Transportation Department Highway Act that authorized that project has nothing to do with the reason that the government officials applying that law in that particular case were arguing that they needed to widen the highway. It's their reason we're interested in. It's that as applied reason, and it's not balancing that's happening at that level. It's a government official saying, this is why we need to apply the law in this way, and then proving whether or not that's necessary. The last thing I'll say is about property rights, or I think I'm out of time, so I'll pause there. I'll have to explain, John, why I think it does apply to other constitutional rights as well.
Okay, Tyler.
Yeah, thank you so much. So John talked about, just to bring us back, he talked about, well, what happens when the content of the law, especially like unwritten law, contract law, for example, talks about a high level of generality, the best way to explain something. And I think, you know, in my paper, I kind of set that to one side in the sense that, you know, my biggest issue is with at least in this instance, we took the effort to identify what the law requires of us first, as opposed to saying, irrespective of what the law requires of us, I just want to choose what's the best rule. But John's point is well taken, because that's the next step, right? Well, what happens when that law requires that? And I think there are two ways you could look at this. One is, you could say that even in these kinds of instances, at least in some of them, not all, there still is an objective right answer as to what best explains. And maybe, you know, best is doing some work there where best in context means a certain thing, whether that's customary, whether that is efficiency. But I understand that that's fighting the hypothetical a little bit, because he mentioned that's not just efficiency. Sometimes what if it's just best and it's abstract at that level? And then even then there's two approaches, and one is to say, again, kind of coming back to what I said at first, at least we're taking the first step to identify that that's what the law is, and that's enough. And at that point, you know, judges are applying law. It's this kind of subsidiary law. They've already found the big, broader concept of law. The second point might be that even in those instances, the law isn't sufficiently concrete enough to be capable of judicial resolution. And so if the law really is something that's abstract, something that's impossible to apply without making fundamental policy choices, maybe the answer is just that whoever's seeking the benefit of that rule loses, and that judges should step aside until there's a more concrete rule to resolve the dispute.
Thank you. Caleb?
All right, well, thanks so much to Robert. Really so pleased to have him comment on my piece. I think he made two major points. The first was that index funds should be market weighted on sort of a more fundamental level, since index funds are replicating the entire equity market. I disagree. I think the primary goal of index funds is diversification. The original index funds were, in fact, equal-weighted funds, not market-weighted, and diversification was their explicit goal. And an equal-weighted fund actually provides much higher diversification relative to capitalization weighting, where your investment is more heavily concentrated. And here's my strongest counterargument. For most of their history, until just the last decade, market weighting was less profitable as a weighting strategy. It actually provided lower returns relative to equal weighting, but it was much cheaper to do. It was lower, had dramatically lower tax liability. So after taking those effects into account, on net, it came out ahead. But the fact to me that market weighting actually produced lower returns for basically its entire history, but still became the dominant weighting strategy despite that, to me speaks to the importance of the structural features that I highlight rather than it being intrinsically better in some way. And the second point, I think that there were some questions about the finance studies, and I'll just respond to the one study that was raised saying basically it was implausible for the 50 largest firms to be so overvalued. And I agree. However, I think the paper is not saying that the stocks are overvalued. I think they believe they're accurately valued, but that essentially this inelastic demand that they have, these index funds have, I'll buy your stock no matter what, rain or shine, has been subsidizing their growth. It's been lowering these firms' cost of capital. So they're not saying that they're mispriced, but rather that their growth has been subsidized by inelastic index fund flows, so they are literally more valuable. Now that may be right or wrong. The finance literature is very much in flux, I think, with respect to their asset pricing models right now. But to me, it's a lot more plausible than framing it as what I totally agree would be an unsustainable level of mispricing. So thank you again so much for your comments. Really a lot of helpful stuff, and appreciate it.
Thank you. Chad?
Great. Well, I really appreciated the feedback. As to the question about why the focus on Aristotle, my goal in this paper is try to keep it the boat, so to speak, as broad as possible, right? To not get into as much modern squabbles and to an effort to introduce virtue ethics to a different field. Of course, you know, your colleague, Professor Solom, has introduced it more broadly. Trying to keep it broad and going back to kind of the fountainhead, so to speak, of Aristotle himself. Although I will say I jumped forward about 1,000 years to Aquinas, so hopefully that, if I was a consequentialist, that would be spectacular. And one of the benefits, I think, of jumping forward to Aquinas is he more systematically organizes the virtues, particularly the four cardinal virtues. So we leave like Aristotle with kind of this, looks like something of an unfinished table of virtues, whereas Aquinas kind of seeks to bring it all together. The four cardinal virtues, cardo, of course, referring to hinge, right? That kind of pivotal virtues. So in this initial paper, just trying to speak more broadly and then perhaps go more narrow within each of those virtues in future work. And then, you know, how might things be different? I think the immediate answer is we might not yet know, and that's partly because the modern administrative state that we have is still fairly new. I mean, you think about the New Deal in the 1970s, and we started talking about X-Men in the 1970s, but that wasn't that long ago. So as to what repercussions might come from having such a large modern administrative state, I would argue that, you know, the ancients are yet to be born, right? It's down the road. So now I want to start thinking systematically about how we should structure the administrative state as compared to kind of like willy-nilly jumping between philosophical perspectives, because we might not yet know what the payoffs would be for tomorrow. But again, thank you very much for the feedback.
Thanks. And Ilan?
Great. Well, I think this is actually the most agreeable John has ever been toward a paper of mine at the initial phase. So and I think I agree with 99% of his commentary, and I'll make the point this way. Here's my story in 3 parts. Part 1, the president's power is the power to oversee execution of law. Step 2, this means the president has the power to remove, but not necessarily to direct. Step 3, therefore the opinions clause does work. Here's what I took John's story to be. Step 1, the president's power is to oversee the execution of the law. He's in charge. He's the chief executive. Same part. Part 2, this can be accomplished through removal or direction, one or the other, as Congress might direct. Now, maybe there are a third, but the president has to be in charge somehow, but Congress has discretion. Step 3, the opinions clause therefore does work. This is a totally plausible story, and it is largely consistent with my story. The only disagreement is that second step, whether the executive power to oversee execution of the law includes removal by constitutional grant or does not necessarily entail removal. And my paper tries to take, while not being about the removal power, takes into account, I think, a lot of evidence about the removal power that I think John's view seems to discount, and I would love to pick his brain about it someday.
Thank you. Well, now, I'm going to first ask if any of the panelists have thoughts about each other's papers.
I don't know anything about index funds.
You probably invested in them, though.
We all should
I
know
liquidated them
something
all
about
during
index.
COVID, actually. So it's burning a hole in my bank account.
Okay. All right, let's open up for questions. Randy.
Randy Barnett from Georgetown. I realized I should have said that for the camera earlier. First of all, John, you need to just take Larry Solom to lunch and ask him about virtue ethics, since he's virtue jurisprudence, since he's one of the world's leading authorities on the subject. So I'm sure that would be beneficial to you both. My comment is actually for Chad, and I have no idea. It's probably in the paper. But as I understand virtue, to be virtuous, it must be internalized. That is, it must affect your character. It becomes what Aristotle would refer to as a second nature. It's not actually your first nature, but it becomes such a part of you that it's as though it's your nature, such that when you go into a store, you don't shoplift. You don't not shoplift because you're afraid of getting caught. You don't not shoplift because it never even occurs to you. When I was a criminal prosecutor, going closer to the idea that I was a member of the government, when I was a criminal prosecutor, I didn't not take a bribe because I was afraid of getting caught. It wouldn't have occurred to me to take a bribe. And partly as a result of that, I was never offered a bribe, I think, because I think I conveyed the kind of attitude that would have suggested that that was not going to be a welcome thing to say to me. So I'm just wondering if that's what real virtue is. Virtue is not doing the right thing. Virtue is because that's great. It's good if you do the right thing, but that's not virtuous. Virtuous is doing the right thing because it's a habit to do the right thing. It's because it's part of you to do the right thing. How does that figure in to the application of this to the administrative state in any way?
Yeah, thank you very much for the question. So I suppose my paper is hyper-focused on a very particular part of society, which is the federal government, particularly the administrative state. But to develop virtue more generally, my broader perspective would be that, we need to make room for things like family values, church freedoms, to raise virtuous future officials from the start. And then I think once you become an official, or perhaps are developing as a professional to become an official, that's when the mechanics of the federal government can apply to you directly and continue to try to develop virtue within those officials. So to use fortitude as an example, or courage, if an official just came to town without any courage, it might be hard to instill that in them. But if they have some, well, then something like continually having to face political dangers, you'll be. The hope is that you would slowly be continually habituated to perfecting your virtue of courage. So I guess as a broad picture, correct. I don't think that the federal government or administrative law can totally make someone virtuous. You have to it has to start much earlier than that. But I'm just focusing on how the mechanics of the administrative state might help.
I had a question maybe a suggestion, comment for Professor Barclay.
Oh, sorry, could you introduce yourself?
Oh, sorry. Hi, yes. Gideon Ramford, recent NYU graduate, currently doing research for the Claremont Institute. So my question is, looking at all these constitutional rights, I think that Professor Harrison suggested you separate them into buckets. And did you consider at any point maybe that just the text itself gives kind of, and I think the Supreme Court grappled with this in Bruin, where they just dealt with the words shall not be infringed, as opposed to other constitutional rights that say, well, okay, you can take property for public use, just give just compensation. Or it has to be a reasonable search and seizure, right? Everybody thinks you can break into a burning building to save someone, but not if there's no reason at all, no suspicion or no warrant, right? So just, can you bracket them based on the textual instruction and then fit that into your whole narrative?
Yes. Sorry, I was enthusiastic in the response. I agree with you. My paper spends a little bit more time about this, but I do think that there are different buckets, both of which can fall under the umbrella of an exclusionary reason, but one is a categorical protection of rights and one is a presumptive protection of rights. Sometimes constitutional text, I think, operates in a way that the best understanding is that any reason for excluding or for interfering with that right is excluded. Double jeopardy, I think, is an example for that. There's not really any permitted constitutional reason why you can allow for double jeopardy to occur. You listed another one where the permissible reason is listed right in the constitutional text. When it comes to public takings, if there's just compensation, the Constitution tells us that's one of the non-excluded reasons that you can limit this right. So I do think, and in a lot of other constitutional systems, more modern constitutions, they have more detailed limitation clauses that provide more explicit explanation of the reasons that are excluded versus permitted. I also think that if you look at the history of the types of reasons that were understood to be permissible for interfering with some natural rights, like religious exercise, that can help you to figure out, are we dealing with a categorical right or a presumptive right? That's something I talk about in my recent article called Replacing Smith in the Yale Law Journal Forum. So I totally agree with you.
Judge Katsas.
Question for Ilan on what the president can or can't do vis-a-vis the bureaucracy. And before you get to history and structural inferences, obviously, there's the text of Article 2. You contrast removal and direction. There's no removal clause. It's inferred from the appointment clause. That seems like a debatable stretch of text. On the other hand, there is the vesting clause, executive power, the take care clause, and it seems like much less of a stretch to say that when the FCC goes off and makes a rule that involves executing the laws of the United States, and it's the president's job to take care. So it would seem like the textual argument to direct seems to me maybe stronger than the textual argument to remove, and you're coming out the opposite.
Yeah, so my intuition is the opposite, actually. Because it seems to me that if the law grants discretion, so long as the officer is properly exercising discretion, even if the president would have exercised it differently, the laws are still being faithfully executed, right? And the removal power allows the president to remove to the extent they're out of. So my sense is the take care clause doesn't do as much work. And the removal power, I actually think, comes from the vesting clause. And it's not obvious. I mean, direction could come from the vesting clause too. Neither might come. I mean, the executive vesting clause could just be an empty vessel. It's just a historical question, what they understood by executive power. And in short, which I didn't talk about here, but the move is the executive power is the power to oversee execution, not personally execute, which requires, at a minimum, the power to appoint. And everybody agreed with that. Even like Julian Mortensen has this paper. He's a progressive legal historian at Michigan. He's like, everyone agreed that the power to appoint assistances to help you was part of the executive power. And then I actually rely on some work with Judge Sugarman has done. Now, this is me on Judge Sugarman, not Judge Sugarman on Judge Sugarman. Judge Sugarman disagrees with me on Judge Sugarman. But as I like to say, he's entitled to his interpretation and inferences, but not to the historical data that he's uncovered. But the power to remove was incident to the power to appoint, which is why no one talks about removal, right? Blackstone barely talks about removal. Why? Because whoever had the appointment power had the power to remove, if for no other reason, than by appointing a replacement. Okay? Now, the question under the Constitution is, the Appointments Clause modifies the power to appoint by giving the Senate a say. Does it therefore also modify the removal, right? No one had to ask this question, right? Because this change, by dividing the appointment power, came in the last 2 weeks of the convention, and no one talked about it. So it wasn't until 1789 when they're like, oh shoot, we've divided the appointment power. Historically, the power to remove came with the power to appoint new people and make new commissions. Well, what do we do now? And then they had to do some other inferences, and they say, well, yes, they're both part of the executive power, and only the appointment part is what's modified, not the removal part. So that's where I get removal from, and it just doesn't follow that direction necessarily. So it's just history, really is the answer, I think, ultimately, to that question.
Thanks.
Thank you. Lee.
Lee Liverman Otis with the Federalist Society. My question is for Tyler. Can you give us a definition of what you mean by judicial lawmaking, or the thing that is that judges are not allowed to do? Because I think this is related to, or it may be the same in some ways as John's question, but I think that the word lawmaking has a slightly tendentious flavor to it. And so I'd like you to tell us what it is that you think judges can't do under the judicial power and what you mean by that.
Yeah, thank you. I think that's a great question. I think, I hit on this a little bit in my paper. A lot of the evidence that I marshaled that they viewed a legislation or lawmaking and interpretation/application as different also then go on to note about how that's a really difficult line to draw, and there's a lot of fuzziness at the line. I think maybe the definition comes best from one example that I think is the strongest, and then there gets a lot of fuzziness, as John was saying. I think this is all right, but I think that we can draw some big categories and go from there. So I think one perhaps is, there's a doctrine, a federal court's doctrine called the Dench Doctrine. And basically what happened is in 1933, Congress creates the FDIC. The FDIC at the time didn't primarily act as receiver, but was primarily engaging in trades to keep banks liquid. So they would buy assets that might be low value to give banks immediate money. And shortly after, this bank sold an asset to the FDIC. It was a promissory note. The individual defaults on the note, and the FDIC sues, and the individual says, well, I had, pursuant to normal, I believe it's Illinois contract law, and the terms of the agreement, I had entered into an agreement with the bank's employees that I had satisfied the note. For whatever reason, I had entered an agreement that I had satisfied the note. And so you can't enforce that against me. And the court acknowledged explicitly, the Supreme Court acknowledged explicitly that the FDIC had no legal defense and that the statute didn't provide for this. And then said, if the FDIC doesn't get extra defense, the 1933 Act cannot work. And therefore, rather than just saying, they get the same protection as a state law purchaser in good faith would have, they said, you just can't enter any evidence of side agreements that aren't in the bank's official records. So even if the FDIC had never bought the promissory note and your agreement between you and the bank is completely enforceable under state law, not enforceable against the FDIC, and that's solely because we think that the Congress's act won't work without this extra rule. And I think obviously that's stark, and I think maybe John and his comments include this under bucket number 2 of fashioning that no one really thinks is okay, and maybe that's true, but I think we can draw lessons from that maybe stark example.
Because that actually doesn't strike me as very persuasive, to tell you the truth. I suspect you can find a lot of examples where courts did things like that, with statutes both in England and in the early days of the Republic and at the state level. I may be wrong about that, but am I wrong about that?
I haven't seen any. If you have any, I'd be happy to see them. There seems to be a lot of treatises in the 1800s that say even in an area where the legislature can act, if they haven't, courts can't do their own common law in that area.
Yeah.
So I haven't seen examples of that,
Okay.
of similar things.
Okay.
And I don't think it's a surprise that this comes in 1944, this initial decision immediately post Erie. But
Okay.
Gene?
Yeah, I wanted to ask our commentators if they have a further response to the responses to them, because I think that might be interesting and useful for the paper writers. But specifically, the one I don't want to let off is Robert, because that was a pretty interesting exchange, and I suspect there's more he has to say, and I think
I'm going to take that as an invitation to go first.
It was.
Yeah, it is. So it can't be diversification. Markovich showed us in the 1950s that once you have about 30 investments in a portfolio, you've captured all the diversification benefits that you probably can. You don't need 500 in the S&P, and you sure don't need 2,000 in the Russell 2000 for diversification purposes. People were investing in all that in order to track the market. It has to be, I think. And the second thing, are the stocks overvalued? Well, these guys' model claims that putting all this money into the index funds, right, creates greater volatility in the prices of the indexed securities, particularly the ones where most of the money is going, the really big cap ones. With increased volatility in the price, right, they say you get a higher risk premium on it, that drives up the price, that's why that's going up. If that is correct, that doesn't strike me as probably remotely correct, but if that is correct, it is purely a demand side feature. It has nothing to do with the present value of the future cash flows of the company. So if that feature is driving the stock price up without changing the present value of the future cash flows of the company, the stock's mispriced, or so I think.
Can you give us a list of the stocks to short?
What are these guys? Everything in the top 50. Apple, Google, NVIDIA. It's all of them. What are these guys?
Dave? Yeah, go ahead.
Oh, yeah, just real quickly. I mean,
Yes, sorry.
Oh, I'm sorry.
I thought
you were
you
flying.
No,
Yeah.
go ahead.
Sorry, that was me.
If I give you a 0% loan versus like a 10% loan, doesn't that change actually the profitability of the company? And I think that's what they're saying. It's saying it is changing. It's subsidizing your investment. You are able to make more investments, and on average, investments are
But the
more
money doesn't
profitable.
go to the company when you invest it.
It lowers their cost of capital.
It
right?
lowers their cost of capital. It'd be a very indirect thing. Lowering their cost of equity capital. I mean, it's not. It's the effect being claimed is enormous.
You may be right, and they've already revised their paper once, so very heavily. So you may be totally correct. So I take your point.
Yeah, but you're right. It does affect their cost of equity capital. That does help them. But I mean, 30% of the value of the company? That's just, I can't be. On Apple alone, it would be worth $600 billion on Apple alone. Can't be.
Yep.
Hi, David Upham, University of Dallas. Two questions, one for Chad, one for Ilan. Chad, in your paper, are you addressing what seems to me to be very important, and that is the architects of the administrative state are dealing with what they consider to be a better anthropology. Maybe they weren't specifically talking about Aristotle, but I think the role of phronesis or prudence for them may be much less or perhaps nothing at all. And also just a different anthropology in terms of the corruptibility of human beings. For Ilan, I'm just curious, I'm sure you address it, but Hamilton's categorical statement, it's just a redundancy, let's move on, in Federalist 74. That's a pretty strong bit of originalist evidence. Actually, I have two questions related to that. And what's the countervailing evidence of that, just not besides the text? And what do you make of the verb may, as opposed to shall have power? Is that distinction important in identifying the extent of the authority of the president?
I can start first. So thank you for that question. I do address it some. So it's interesting. I think it was Wilson, his conception of like how we should train administrators aligns a lot with, I think, what we get from virtue ethics, where Wilson says, you know, we'll have like, there'll be professionals and they'll receive special education, and then they'll receive like constant drilling, so to speak. And I think of that as like, okay, like intellectual virtue, you can get that through education, and then like constant drilling seems very similar to, I think, the type of habituation that we typically look for in developing moral virtues. And I think the architects, the Landises of the world, just looked too narrowly. In the paper, I draw out that, you know, when thinking about, okay, we're going to have technocrats with certain types of expertise, environmental, workplace, SEC. Sure, that's important, but that's like what Aristotle might refer to as techne, right? Just like a very specialized form of knowledge. And I'm saying, great idea, we'll start there, but now look more broadly at the virtues of officials more generally, including prudence, where you would say, okay, I have this very important skill set of technocratic expertise, but am I prudent enough to recognize how it fits into the broader mission of the federal government, the broader mission of society?
So Hamilton was wrong about a few things, by the way, like the residual vesting of executive powers. I don't think that's true, but there is an illustrious list of people who thought that the opinions clause was redundant, like Chief Justice Taft in his book calls it minor. Justice Jackson in Youngstown calls it a trifling power. The only one that I think at the time who said, oh, it's just redundant is Hamilton, as far as I know. Okay, that doesn't mean there aren't others. And Richard Henry Lee, by the way, said, yeah, if you're right about removal power, then it is redundant, and that's bad. That's why there can't be a removal power, right? So you have Richard Henry Lee in this letter versus Hamilton. And so, yeah, I put Hamilton's letter along with Andrew Jackson's protest on the protest, you know, protesting his removal of the Treasury Secretary, and along with Caleb Cushing's when he was Attorney General. There is countervailing evidence, to my view, to the effect that the executive power does include the power to direct and control the discretion of subordinate officers, including principal officers. And Hamilton is one of them. But it was and I used to believe that, right? This is kind of like my other incorporations. Like I used to think that was obviously right. Turned out I don't think that's right at all. It's the same thing here. Like I assumed that was the answer. And then it turns out there's a lot less evidence for that than I had believed.
Yeah, we have time for one more question.
Moin, University of Alberta. A question for Caleb, just to build on Robert's comment. So, if I'm understanding this correctly, the these index funds have lower cost of capital, which means either the beta has gone down, the market return as a whole has gone down. You need to somehow give us a story of how these 50 firms are somehow lowering the entire market's value, or somehow the correlation with the market has gone down. I mean, that maybe it's your zero elasticity story, but still, that shouldn't give that big. The other option is, of course, that the risk-free rate has, in the last 10 years, has basically gone to zero. So maybe that's what's driving it. But there should be, I think, unless it's in your paper, which I haven't read, we need a better sort of causal story other than, irrespective of what that paper that you're citing to is talking about.
Yeah, thank you for that question. So maybe I'll just delete that study from my paper. I there's I think 40 or 50 others that I think support some other aspects of the piece, but that one is I had some questions too. I pulled up an email exchange I had with one of the authors there, and I think they're still kind of working through the mechanism. But it is essentially a repricing of idiosyncratic risk. So because market weighting is so complicated, if you invest $100,000 in an S&P 500 fund, about $30,000 of it is going to go to the top 5 to 7 companies. Okay, what they say is we should have it's impossible to diversify that risk away because it's such a large piece of our economy. So if Apple fails, it's a big deal. If Amazon fails, it's a big deal. And so there's idiosyncratic risk that can't be diversified away as opposed to systemic risk, or other risks that can be diversified away. So what these inelastic index funds do is they cause this repricing of idiosyncratic risk, where it should be, I don't want to invest so much in such a heavily concentrated basket. index funds say, I in fact do want to invest exactly that much in a very heavily concentrated basket. And so that causes their prices to rise more relative to the lower firms who don't possess that idiosyncratic risk to be taken away. Does that make sense? So that's their mechanism. My paper is not really super reliant on that. I mean, I think my broader point is simply that index funds are not passive in their market impacts. We need to think about it. I'm not on a crusade, for or against any sort of particular weighting strategy. But I think, when we talk about what do they do to market efficiency, what percentage of index funds can we have before it destroys accurate pricing? What percentage of active investor versus passive? Well, it matters what type of passive investors we have. So I think it bears on a lot of those questions.
Yeah. Thanks very much. Thanks very much to the panelists who've done a marvelous job here and to the audience.
Thank you. We need that private lobby.